Hey there, in this video I'm going to be explaining what happens when a domestic violence alleged victim does not show up for trial. My name is Veronica. I am a criminal defense attorney here in Los Angeles, and I help people who have been arrested put their criminal cases behind them so that they can enjoy their lives and their freedom. And again, in this video we are going to be talking about what happens if the victim in a domestic violence case does not show up for trial. So first of all, let me get this out of the way. If the victim in the case does not want to push the case forward, that doesn't mean that the case will get dropped. I mean, I have cases all of the time where it is actually the wife or the girlfriend or whomever who's calling me saying like, hey, I don't want these charges to go forward. They're the ones who are retaining me, paying me, whatever. Obviously, they don't want the case to go forward, right? But that part doesn't matter, okay? So just because the alleged victim in a case does not want to go forward doesn't mean that the case will go away. What happens is that once the police take the police report and the DA takes on the case, then you basically, as the alleged victim, have no power. And there are many things I can say about this. The nicest thing I can probably say is that it is infantilizing to the alleged victim to say, hey, you don't know what's best for you, and so we are going to go ahead and prosecute this case, whether you like it or not, because that is what the state does. That is what the DA's office does. That's what the prosecution does all throughout the entire state of California. The only other state that I have experience in is Illinois. I was a law student there. I was never a lawyer there. But I did work, I interned for the public defender's office, and it was the same there. So I imagine it is the same across the country, but in California and LA, I think that it's especially bad. They still have a chip on their shoulder, they meaning law enforcement, because of O.J. Simpson. They believe that every time that they come out and they want to make, and for a domestic violence case, they should make an arrest. Okay, so let's put all of that behind us. Just because the victim doesn't want to prosecute doesn't mean really anything about the case. Like, sure, it's a little bit better than if she was calling up the DA's office saying, hey, I want him to get the max. This was so horrible. Sure. Yeah, that's true. It's a little bit better. But it doesn't make a big difference in getting the case dropped. So let's say that we have the trial set, right? Let's say the DA's office is not willing to work with us. They will not drop the charges. They will not drop them down. Nothing. Okay, so we set the case for trial, and the alleged victim does not show up. What happens with the case? Well, it really depends. It depends on what other evidence that they have. So let's say the only evidence that they have is that they expected her to show up and testify and say that the defendant beat her up, and she's not here. Okay, so now they no longer have that evidence. Maybe they have police officers that she said that to, but if they don't have any sort of body-worn video, they don't have anything like that, it's hearsay. If they do have body-worn video, it's at least arguably hearsay. Sometimes it does end up coming in, sometimes not. Hearsay means it doesn't come in unless an exception fits. We spend a lot of time on that in law school because it is actually a very confusing issue, which is why I'm not explaining it too much more. But generally, you can't have, for example, a police officer come in at trial and say, well, the victim told me XYZ. You can't do that. Can you have a video of her saying XYZ? Maybe, maybe not. It depends on the circumstances, because the definition of hearsay is an out-of-court statement offered at trial for the proof of the matter asserted. So if you're showing an out-of-court statement, so she wasn't under penalty of perjury, for example, when she made that statement to the cops, right? And you're offering it at trial to say that whatever she's saying was true. Well, maybe she was drunk at the time. Maybe she thought, you know what, I just want to get the cops the heck out of here, or I just don't want to get arrested. I need to just get them to leave, so she's saying what they want to hear. And that is actually very, very common. That cannot be offered at trial. Maybe in body-worn video, but generally not. So that's helpful, but what can be offered is the statements of officers. So what I always ask clients, generally even in the very first phone call, is, were there any injuries? Now that's going to be a big thing. If there were injuries very visible when the cops showed up, that is going to come out at trial. That will come out at trial. That is not hearsay. They're going to have cops that show up and talk about that at trial. They're going to have pictures that they show, and that's going to be a big thing. Now, whether or not that hurts you depends on if there were any injuries or alleged injuries, how bad those actually were. Many times there's like an old bruise, and I've told even DAs before, and I have a long sleeve top on right now, but I've told them, sometimes the cops will come out on a domestic violence call and they see a bruise on the alleged victim's like arm or leg, and they take a picture of it as though it was just made. But I personally, I always have like at least some kind of bruise on my body. I'm a clumsy person. I have pale skin, and I will just end up bruised very, very easily. And that happens to a lot of people, whether or not you have pale skin, you have some kind of bruise from whatever, and the cops come out and, they'll start taking pictures of it. And what are you supposed to do? I mean, I would say run back inside, cover yourself up, definitely. But I can imagine answering the door in, a robe if it's late at night, as it is many times for domestic violence calls, and the cops seeing like my legs and saying, okay, I ran into something, I have some kind of bruise, or I don't know, mosquito bite scars, whatever, and like taking pictures of those, and they can look bad close up, but that doesn't mean that there was an actual injury. So that's one thing that they will use. Photos of the injuries, testimony of the officers about that. The second thing is, are there any independent witnesses that are going to testify in the prosecution's favor? So if there's a neighbor, for example, that heard the alleged victim yelling, stop hitting me, then of course that is going to be used against you. They are going to have that victim or the witness come in and testify to that, and that will be unfavorable to you. But if they don't have any photos of injuries, they don't have any statements that they can bring in from the alleged victim, or maybe when they showed up, she said, hey, there's nothing going on here, please leave. There are no independent witnesses, then they really aren't going to have a lot at trial. But the thing always is with trial that to get to that point, you have a lot of risk going forward, especially with felony charges. You have a lot of risk going forward of potentially going to prison if you lose. So what generally I advise people to do is use all of this and have your attorney talk to the DA before the trial to, talk through with the DA, hey, how all this is going to play out. And try to get you an offer that's maybe classes in exchange for a dismissal, where you won't have any kind of felony or misdemeanor record at all. That can be really important. But, every attorney who is a litigator, we do this because we like going to trial. We like going to court. It's not so that we can get people deals. So, of course, I do like going to trial. And I have had cases that do end up going to trial. A lot of domestic violence cases, because that's what I do. Sometimes the DA is just really stubborn. Sometimes the alleged victim really, really wants to push it. And so the DA, does that on their behalf. They don't want to drop it down or whatever because of that. But despite my love of trials, because they're risky, if you can possibly avoid them, my advice is to definitely do so. If it were my case or my loved one's case, I would definitely, even if I thought we had the greatest case in the world, I have the alleged victim who's going to go up on the stand, say she was lying, whatever. I would advise them, if possible, to try to get something where it's a dismissal before the arrest date, if possible, or to get classes in exchange for a dismissal. Because, again, the victim just not showing up at trial or not cooperating doesn't necessarily mean that you win. And I'm not going to get into this much because this would be a whole other video, but sometimes I will have the alleged victim actually go on the stand instead of refusing to testify. They're on our side, actually go on the stand and testify and explain what happened, explain a scenario in which it was self-defense on the other side, or the cops are wrong, or whatever it may be. That's a last resort as well, because if that person screws up, and a lot of people, you may think you will be a great witness. A lot of people do not end up being great witnesses, but it's a last resort because easily that can falter, or that person can feel like, oh, well, now I have power over you, so I'm going to maybe change my mind. Like, that's what I really want to avoid with a lot of my clients and what I advise them for domestic violence. But as a last resort, if we have the victim on our side, we will have her testify, generally prep her ahead of time and make sure that everything that she says is in support of you being innocent. Anyway, I hope that this video helped. If you do have a case in California, not just Los Angeles, but in California, feel free to book a call with me down below. You can also find my number right down there.